Your child broke the local noise control rules.
3 neighbors recorded you forcefully pulling him away.
When Diane Kowalski grabbed my 8-year-old son's arm and dragged him across our front lawn, she was screaming about noise violations. When Tyler started crying and calling for his mommy who died 2 years ago, the board president didn't stop. When 3 different neighbors pulled out their phones and started recording, the woman from the corner lot just kept going. She made 3 mistakes that afternoon. She assaulted the wrong child, she threatened the wrong father, and she forgot that sound measurement isn't subjective, it's science. My name is Nathan Cross. I'm an audio engineer certified in ANSI acoustic standards. I measure sound levels for environmental impact assessments. I testify as an expert witness in noise litigation, and I just proved that Diane Kowalski's noise ordinance violates Arizona state law. If you've ever watched someone abuse authority they don't actually have, stay with me and hit subscribe now. My wife Jennifer died in a car accident 2 years ago. Before the cancer diagnosis that we didn't know about, before the seizure that caused her to lose control of the car, she made me promise one thing. Keep Tyler's therapy going, no matter what. He needs it. Tyler has autism spectrum disorder. His occupational therapist prescribed sensory play, specific toys that help him process emotions and regulate his nervous system. A rainbow xylophone his mother bought him 3 weeks before she died. Jennifer recorded herself playing a simple song on it, telling Tyler, "Mommy will always make music with you." Every afternoon at 4:30, Tyler sits in our front yard and plays those same notes. It's not just play, it's medical treatment, it's grief processing. It's the only way my son stays connected to the mother he lost. Diane Kowalski grabbed him while he was playing his mother's song, dragged him across the lawn, ripped the xylophone from his hands, told him he was breaking rules and she was confiscating noise-making devices. Tyler had a complete meltdown, the kind that takes hours to calm down from, the kind that sets his development back weeks. The board president walked back to her house with my son's xylophone, the last gift from his dead mother, and she refused to return it. Tyler hasn't spoken since, not a single word. His therapist calls it selective mutism, trauma-induced silence. My 8-year-old son lost his voice because an HOA president decided a child playing a toy xylophone at 4:30 in the afternoon was a noise violation. What happened next? I pulled out my professional sound level meter. I contacted the Arizona Department of Real Estate. I filed an ADA complaint with the Department of Justice. And I discovered that the self-appointed enforcer had been breaking state law for 6 years. The neighbor footage arrived in my email within an hour of the assault. 3 different angles. Mrs. Patterson from across the street had captured it from her doorbell camera. The Hendersons next door had filmed from their living room window. And Mark Chen, 2 houses down, had been watering his lawn with his phone already out, recording the whole thing in HD. I sat at my kitchen table and watched my son get assaulted over and over again. Diane approaching while Tyler played his xylophone, her face twisted with rage. Tyler looking up, confused. The board president grabbing his arm hard enough that he dropped his toy. Tyler trying to pull away. The woman from the corner lot dragging him 3 feet across the lawn before I burst out the front door. The audio was the worst part. Tyler screaming, "Mommy, I want mommy," over and over. Diane yelling, "This noise ends now. I'm confiscating this equipment." My own voice, desperate and furious. "Let go of my son." And then Tyler's sudden silence after Diane finally released him. That horrible, complete silence. I forwarded all 3 videos to the Maricopa County Sheriff's Department and filed a criminal complaint for assault on a minor and theft of property. Then I called Tyler's pediatrician and scheduled an emergency appointment to document his injuries. Red marks on his arm where Diane had gripped him, scraped knee from where he'd stumbled, and the psychological trauma that was manifesting as selective mutism. Dr. Sarah Kim examined Tyler with gentle thoroughness while I explained what happened. She photographed every mark, documented his refusal to speak, asked him yes or no questions that he could answer by nodding or shaking his head. "Has this ever happened before?" Dr. Kim asked me quietly, while Tyler colored in the corner of the exam room. "The assault? No. But Diane's been escalating for weeks. Started with a letter saying Tyler's outdoor play violated noise ordinance, then threatening daily fines, then showing up at our house to measure sound levels with her phone." "With her phone?" Dr. Kim's eyebrows rose. "That's not exactly professional equipment." "No, it's not." I pulled out my own phone and showed her the email I'd received from the HOA 2 weeks prior. She claims any outdoor noise exceeding 50 decibels during quiet hours is a violation. Quiet hours apparently being any time she decides they are. Dr. Kim read the email, her expression darkening. "Your son's therapy is medically necessary. She can't restrict that." "I know. That's why I'm fighting this." I glanced at Tyler. He'd stopped coloring and was rocking slightly, a self-soothing behavior that meant he was overwhelmed. "But I need documentation. For the police report, for the lawsuit I'm filing, for the ADA complaint." "You'll have it." Dr. Kim closed her laptop. "I'm writing a detailed report about Tyler's autism, his prescribed therapy regimen, and the harm this assault has caused. Selective mutism is serious, Nathan. It could take months for him to recover, if he recovers at all without proper intervention." I felt something cold settle in my chest. If trauma affects autistic children differently, Tyler's already dealing with grief from losing his mother. This assault, the loss of his comfort object, the disruption to his routine. She looked at Tyler with obvious concern. He needs stability, safety, and he needs that xylophone back. Diane won't return it. She says it's confiscated evidence of a noise violation. Then we document that too. The deliberate withholding of a therapeutic tool from a disabled child. Dr. Kim's voice was steel. "I'll include it in my report to Child Protective Services." My head snapped up. "CPS? An adult assaulted your disabled child and is withholding his medical equipment. Yes, CPS needs to know." She held up a hand before I could protest. "Not because you did anything wrong, because they need to investigate Diane Kowalski for child endangerment." I left the pediatrician's office with a 5-page medical report, photographs of Tyler's injuries, and a referral to a child psychologist who specialized in trauma. Tyler held my hand the whole drive home, but didn't make a sound. When we pulled into our driveway, I saw Diane standing on her porch across the street, watching. She had her phone out, pointing it at us, still measuring, still monitoring, still convinced she had authority over our lives. She had no idea what was coming. Rachel Torres knocked on my door at 8 p.m. that same evening. I recognized her from HOA meetings, always sitting beside Diane, taking notes, nodding along with whatever the board president said. The treasurer who rubber-stamped every decision. I almost didn't open the door. "Nathan, please, I need to talk to you." Rachel's voice was barely above a whisper. She glanced over her shoulder toward Diane's house, like she expected to be caught. "It's about what happened today." I opened the door, but didn't invite her in. Couldn't. Not with Tyler finally asleep upstairs after hours of rocking and silent tears. Rachel stayed on the porch, hands twisting together nervously. I saw the video. Mark Chen sent it to the board email. Diane's claiming Tyler attacked her first, that she was defending herself, that the video is edited to make her look bad. My 8-year-old autistic son attacked her. My voice was flat, while playing a xylophone in his own front yard. I know. Rachel's eyes filled with tears. I know it's insane, but she's convincing Linda and Steve that you're the problem, that your son is a danger to the community because he's unpredictable. Rage burned through my chest. She said that? In the emergency board meeting she called an hour ago. Rachel pulled out her phone, showed me an email thread. She wants to issue a cease and desist order banning Tyler from the front yard entirely. She's claiming his autism makes him a liability concern. I stared at the emails, legal-sounding language wrapped around disability discrimination. The board president was actually trying to ban my disabled son from our own property. "Why are you telling me this?" I asked. Rachel's hands were shaking now. "Because my son Jacob is in Tyler's class. He has ADHD. He's struggled so much this year, and Tyler has been kind to him when other kids weren't. Jacob came home crying today because Tyler wouldn't talk to him at school, and when I explained what happened," she wiped her eyes. "My son is heartbroken that someone hurt his friend, and I'm terrified that if Diane can do this to Tyler, she'll eventually target Jacob too. So this is self-preservation." "Yes." Rachel didn't flinch from the accusation. "But it's also because what Diane did is wrong. Completely, unforgivably wrong. And I've been complicit in her tyranny for 3 years because I was too afraid to stand up to her." She pulled a flash drive from her pocket. "This has every financial record for the HOA since Diane became president. Bank statements, invoices, fine collection records, everything." I took the flash drive slowly. "Why?" "Because I'm the treasurer. I see where every dollar goes. And Nathan..." Rachel's voice dropped even lower. "Diane's been stealing from us. She created a fake enforcement coordinator position and pays herself 15% of every fine she collects. Last year alone, she made $7,000 from fines she issued, most of them for noise violations that don't actually exist in our bylaws. She's embezzling HOA funds. Yes, and I have proof. Bank transfers to her personal account, invoices she forged, board meeting minutes I altered at her direction to make the payments look legitimate." Rachel met my eyes. "I'm guilty too. I falsified financial records because she threatened to ruin my teaching career if I didn't cooperate. But I can't do this anymore. Not after watching her assault a child." I looked at the flash drive in my hand. Evidence of financial crimes. Proof of corruption. Ammunition that could destroy the board president. "If I use this, you'll be implicated." "I know." Rachel's jaw set with determination. "I'm prepared to face consequences for what I've done, but Diane needs to be stopped, and Tyler needs his xylophone back." She turned to leave, then paused. "Nathan, Jacob told me Tyler plays the same song every day, the one his mom taught him. Jacob said it's the prettiest song he's ever heard." My throat tightened. "Diane stole more than a toy," Rachel said quietly. "She stole your son's connection to his mother. That's unforgivable." She walked back toward her house, shoulders straight despite the shaking hands. I stood on my porch holding evidence of embezzlement and fraud, watching the tyrant's house across the street. The woman from the corner lot had made a powerful enemy in Rachel Torres. She just didn't know it yet. The sheriff's deputy who responded to my assault complaint arrived Friday morning. Deputy James Morrison was in his 50s, with the weathered look of someone who'd seen too much and wasn't easily impressed. I showed him the 3 videos, watched his expression harden as he witnessed Diane dragging Tyler across the lawn. "That's clear assault on a minor," he said. "How old is your son?" 8, and he has autism spectrum disorder. I handed him Dr. Kim's medical report. The xylophone she confiscated is prescribed therapeutic equipment. Tyler hasn't spoken since the assault. His doctor diagnosed trauma-induced selective mutism. Morrison read through the report carefully. "Where's the xylophone now?" "Diane still has it. She's refusing to return it, claiming it's evidence of a noise violation." "Evidence?" Morrison's eyebrows rose. "Of what crime?" "That's my question." I pulled out my professional sound level meter, a Brule & Kjær Type 2250 that cost $8,000 and was calibrated to ANSI S1.4 standards. "I'm an audio engineer. This is the equipment I use for environmental noise assessments. Would you like me to demonstrate what sound level Tyler's xylophone actually produces?" Morrison nodded. I retrieved the spare xylophone I'd bought, identical to the one Diane had stolen, and set it up in the front yard. Used the mallets the same way Tyler did, played the simple melody Jennifer had taught him. The meter read 48 decibels at 5 feet, 52 decibels at the property line. "For context," I explained, "normal conversation is 60 decibels. A dishwasher is 55. Tyler's play therapy was quieter than someone talking on their front porch." Morrison wrote everything down. "And Ms. Kowalski claims this violates HOA noise ordinance?" "She does, but here's the thing." I pulled out my laptop and showed him the research I'd done over the past 3 days. Arizona Revised Statutes, Section 33 to 1808, prohibits HOAs from enforcing rules that conflict with state or federal law. Arizona's noise ordinance, per state environmental quality standards, sets residential daytime limits at 65 decibels. The HOA claims authority to restrict noise to 50 decibels, which is more stringent than state law allows. So the HOA rule is unenforceable. Completely. They literally cannot legally restrict sound levels below the state threshold. I showed him more documentation. Additionally, under the Americans with Disabilities Act, HOAs must provide reasonable accommodations for disabled residents. Tyler's outdoor sensory play is medically prescribed therapy. The HOA cannot ban or restrict it without violating federal disability law. Morrison studied the documents. "You've done your homework. My son lost his voice because someone abused authority she doesn't have." "Yes, I've done my homework." "Okay." Morrison closed his notepad. "I'm filing this as assault on a minor and theft of property. Given the disability aspect and the video evidence, the DA will likely prosecute. But I need to warn you, HOA disputes get complicated. Ms. Kowalski will claim she was acting in her official capacity, that she had authority to enforce rules, that she didn't intend harm. The intent is irrelevant. She grabbed a child and caused injury. That's battery regardless of her perceived authority." I agree, but juries sometimes give HOA board members the benefit of the doubt. Morrison stood. "My advice? Lawyer up, file a civil suit, and contact the Arizona Department of Real Estate. They oversee HOA compliance with state law. If this noise ordinance is really illegal, DRE can shut it down." After Morrison left, I sat at my kitchen table and made a list. Criminal charges filed, medical documentation, complete video evidence secured. State law violation, identified financial fraud evidence obtained. Next steps. 6. Hire attorney specializing in disability rights and HOA law. 7. File ADA complaint with Department of Justice. 8. File complaint with Arizona Department of Real Estate. 9. Submit CPS report. Dr. Kim already did this. 10. Demand return of xylophone through legal channels. Tyler appeared in the doorway, silent as always now, holding the new xylophone I'd bought. He looked at it, looked at me, set it down, and walked away. He didn't want a replacement. He wanted his mother's xylophone, the one with her fingerprints on it, the one she'd held and played and laughed while recording that video, the one Diane Kowalski had stolen. I opened my laptop and started searching for attorneys. The self-appointed enforcer had assaulted the wrong child. She was about to discover exactly how wrong. Monday morning, I carried my professional sound measurement equipment to the front yard and conducted a full acoustic survey, not with a phone app like Diane used, with calibrated ANSI-certified instrumentation that would hold up in court. I measured background ambient noise, 43 decibels, traffic from the main road, 58 decibels, the Henderson's lawnmower 3 houses down, 72 decibels, someone's air conditioning unit, 51 decibels. Then I played Tyler's xylophone, the replacement, at his exact typical intensity and duration, measured from multiple locations: our property line, the sidewalk, Diane's front porch across the street. Maximum reading, 53 decibels. Average, 49 decibels. Duration, 12 minutes. I documented everything with timestamps, GPS coordinates, weather conditions, and equipment calibration certificates. Professional environmental noise assessment, the kind I'd submit for commercial development projects or industrial compliance reviews. Then I pulled up Arizona's noise regulations and cross-referenced every standard. Arizona Administrative Code, R18-4 Walamsen-01. Residential daytime noise limit is 65 decibels measured at property line. Tyler's xylophone was 12 decibels below the legal threshold. Maricopa County Noise Ordinance, 65 decibels during daytime hours, 7 a.m. to 10 p.m. Tyler played at 4:30 p.m., well within permitted hours, well below permitted levels. Phoenix City Code, no restrictions on residential outdoor activities producing less than 60 decibels during daytime. Every level of government, state, county, city, agreed. Tyler's play therapy was perfectly legal. But Pinewood Meadows HOA claimed authority to restrict noise to 50 decibels during quiet hours that extended from 2 p.m. to 6 p.m. I pulled up the HOA's CC&Rs and bylaws, read through every noise-related provision, and I found the smoking gun. The noise restriction wasn't in the original CC&Rs filed when the neighborhood was established in 2010. It had been added in 2019 via a board resolution that Diane had written and implemented without a homeowner vote. Arizona Revised Statutes, Qarav 33-1808, was crystal clear. HOA rules cannot be more restrictive than federal, state, or local law unless specifically authorized by the CC&Rs and approved by membership vote. Diane's noise rule was more restrictive than state law. It wasn't authorized by the original CC&Rs, and it had never been put to a homeowner vote. The rule was completely, absolutely, legally void, which meant every fine she'd issued for noise violations over the past 6 years was illegal. Every penny collected was obtained through fraud. I cross-referenced Rachel's financial records with the HOA's published violation reports, found 87 noise violations issued since 2019, total fines collected, $31,400. Diane had personally received 15% of that through her fake enforcement coordinator, payments, $4,710. I drafted a formal complaint to the Arizona Department of Real Estate, attaching my professional acoustic analysis, Comparison with state, County, city noise standards. HOA bylaws showing no authority for the 50 decibel rule. Timeline showing rule was added by board resolution without vote. Financial records showing illegal fine collection. Evidence of Diane's personal enrichment from enforcement. Then I drafted a second complaint to the U.S. Department of Justice Civil Rights Division, attaching Dr. Kim's medical report on Tyler's autism and therapy needs Dr. Elena Martinez's, his occupational therapist, statement that sensory play is essential treatment. Documentation that HOA denied reasonable accommodation. Evidence that HOA specifically targeted disabled child engaging in medical treatment. Video footage of assault during therapeutic activity. Americans with Disabilities Act, Title II. Public accommodations must provide reasonable accommodations for disabled individuals. While HOAs aren't technically public, courts have consistently ruled they must comply with ADA when their rules affect disabled residents' access to common areas and reasonable use of property. Tyler's front yard therapy sessions were reasonable use of property, below legal noise thresholds, medically necessary, time-limited, non-invasive. The HOA's refusal to accommodate was textbook disability discrimination. I hit send on both complaints. Then I called the attorney I'd researched, Marcus Webb, who'd won 3 major cases against Arizona HOAs for civil rights violations and had successfully sued 2 HOA boards for disability discrimination. Mr. Cross, I've actually been following your case, Webb said when I explained the situation. The neighbor footage made local news. This morning, Channel 12 ran a story about an HOA president assaulting an autistic child over a toy xylophone. My stomach dropped. What? Someone sent them the video. It's gone viral. 500,000 views in 6 hours. The comments are, "Not kind to Ms. Kowalski." I pulled up the news station's website. There it was. HOA president caught on camera dragging autistic child for playing music. The video had been edited to show the assault in brutal clarity. Tyler playing peacefully, Diane storming over, the grab, the drag. Tyler's screams for his dead mother, the xylophone falling, Diane walking away with it while Tyler sobbed on the lawn. "Mr. Cross," Webb's voice pulled me back. "I'd like to represent you, pro bono if necessary. What Diane Kowalski did violates state law, federal disability law, and basic human decency. I want to destroy her." "Get in line," I said. Tyler's psychologist, Dr. Sarah Chen, called an emergency session Tuesday afternoon after seeing the news coverage. "Nathan, I need you to understand something." Dr. Chen's voice was gentle but urgent over the phone. "Tyler's selective mutism is a trauma response, yes, but it's also a coping mechanism. He's processing multiple layers of grief: his mother's death, the loss of his routine, the physical assault, and now the public exposure of his most vulnerable moment. I didn't leak the video. I know, but it's out there. And Tyler knows. His classmates have seen it. Their parents have seen it. He's aware that his worst day is public knowledge." She paused. "I'm concerned about regression. Tyler was making real progress in his grief work. This assault has undone months of therapy." I looked at Tyler, sitting on the couch, staring at the blank TV. He hadn't turned it on, hadn't played with any toys, hadn't attempted to go outside since Wednesday. My son was disappearing into himself. "What do I do?" I asked. "Fight, win, get his xylophone back, show him that adults can protect him, that justice exists, that his needs matter." Dr. Chen's voice strengthened. "And document everything for the lawsuit. Tyler's regression is a direct result of Diane Kowalski's actions. She didn't just assault him physically, she destroyed his sense of safety." After the call, I sat beside Tyler on the couch. He didn't look at me. "Buddy, I know you're scared. I know that woman hurt you, but I promise you—" My voice broke. I'd promised Jennifer I'd protect him. I'd failed. "I promise I'm going to make this right. You're going to get Mom's xylophone back. And you're going to be safe again." Tyler's eyes filled with tears, but he didn't make a sound. I pulled him into my arms and held him while he cried, silently. The email from Marcus Webb arrived that evening with a draft complaint for civil court. 16 pages detailing causes of action: battery, assault on minor; theft, xylophone valued at $35 but priceless as memento; intentional infliction of emotional distress; disability discrimination; ADA violation; violation of Arizona HOA law; illegal noise ordinance; fraudulent fine collection; embezzlement, self-dealing payments; damages requested; return of xylophone medical expenses for Tyler's therapy, ongoing; compensatory damages for emotional distress, $100,000 punitive damages, $500,000; attorney fees; injunctive relief prohibiting HOA from enforcing illegal noise rules. The punitive damages are key, Webb had written in his cover email. Arizona allows substantial punitive awards when defendant's conduct is especially reprehensible. Assaulting a disabled child to enforce an illegal rule? Juries hate that. We'll hit her hard. I signed the complaint authorization. Then my phone rang. Unknown number. "Mr. Cross, this is Vanessa Rodriguez from the Arizona Department of Real Estate, HOA Compliance Division. I'm calling regarding your complaint against Pinewood Meadows HOA." My pulse jumped. That was fast. "Your complaint included evidence of illegal rule enforcement, financial misconduct, and disability discrimination. Those are priority flags for our department." Papers rustled in the background. "I am assigning an investigator immediately. We'll need to review all HOA financial records, bylaws, board meeting minutes, and fine collection procedures. The treasurer has been cooperating. She can provide financial records." "Good. We'll need her formal statement. Mr. Cross, I want to be clear about what we're looking at here. If your evidence is accurate, the HOA has been operating in violation of state law for 6 years. We have authority to impose significant penalties, freeze HOA accounts, remove board members, and even dissolve the board entirely if violations are severe enough. What happens to the fines people have already paid? Restitution. If fines were collected through illegal rules, they must be returned to homeowners. With interest." Rodriguez's voice hardened. "And if there's embezzlement involved, that's criminal. We'll refer to the Attorney General's office for prosecution." After we hung up, I updated my case status list. Criminal charges filed, under investigation. Civil lawsuit filed, awaiting service ADA complaint. Filed with DOJ state DRE complaint, under active investigation. Financial fraud referred to AG's office CPS investigation. Ongoing. The walls were closing in on Diane Kowalski from multiple directions, but she didn't know it yet. I watched her house across the street, lights on in her living room, her white sedan parked in the driveway. Life continuing normally for the self-appointed enforcer who'd assaulted my son. That normalcy was about to shatter. My phone buzzed. Text from Rachel Torres. "Emergency board meeting tomorrow night. Diane's planning to issue formal trespass warning against Tyler. She wants to ban him from all common areas, including sidewalks." I typed back, "Let her try. Every move she makes now is evidence." Rachel. "I'm voting against her, whatever she proposes. Just so you know." The conflicted witness was becoming an ally. The tyrant's support was crumbling, and my son was still silent, still traumatized, still waiting for the world to make sense again. I looked at Tyler sleeping on the couch, exhausted from crying without sound. "Soon, buddy," I whispered. "Justice is coming soon." Hit subscribe right now if you want to see how a single father takes down an HOA tyrant who assaulted a disabled child. Where are you watching from? Rachel Torres knocked on my door Wednesday evening, 30 minutes before the emergency HOA board meeting was scheduled to start. "I'm resigning from the board tonight," she said without preamble. "I can't do this anymore. But before I do, I wanted you to know what Diane's planning." She handed me a printed agenda. Item 3. Motion to declare Tyler Cross a community safety hazard and restrict access to all common areas. My vision blurred with rage. She's trying to ban my disabled son from sidewalks. She's claiming his unpredictable behavior poses a liability risk, that the HOA's insurance requires restrictions on residents who might cause injury or property damage. Rachel's voice shook. "Nathan, she's building a paper trail to justify her assault. If she can retroactively classify Tyler as dangerous, she can claim she was acting to protect the community. That's disability discrimination on top of everything else." "I know. That's why I'm bringing this." Rachel pulled a thick folder from her bag. Complete financial records for the past 6 years. Every fine Diane issued. Every payment to her fake enforcement coordinator position. Every board vote she falsified. Every email where she told me to alter the books. I took the folder carefully. "Rachel, this implicates you too." "I'm aware. My attorney says I might face charges for falsifying financial records, but I'm cooperating with DRE investigators, and I'm willing to testify against Diane. Sometimes you have to face consequences for doing the right thing, even if you should have done it sooner." Her eyes were red from crying. "Jacob asked me yesterday why Tyler won't talk to him anymore. I had to explain that a grown woman hurt his friend so badly that Tyler lost his voice. My son looked at me and asked if I was going to let that woman hurt anyone else." "What did you tell him?" "I told him no, that I was going to help stop her, that adults have to protect children even when it's scary." Rachel wiped her eyes. "So that's what I'm doing. Here's every piece of evidence you need to destroy her." Inside the folder, bank statements showing $47,000 in noise violation fines collected since 2019. Transfer records showing $7,100 paid to Diane personally as enforcement coordinator fees. 87 violation notices, 43 of which were issued to families with young children. Email threads showing Diane specifically targeting families she deemed disruptive. Board meeting minutes showing votes that never actually happened. Text messages between Diane and the other board, members coordinating their false narratives. "This is embezzlement evidence," I said. "Yes, and conspiracy, and fraud. The AG's office is going to love this." Rachel checked her watch. "Meeting starts in 20 minutes. I'm going on record opposing every motion Diane proposes. Then I'm resigning and recommending the entire board be dissolved for corruption." "She'll retaliate." "She'll try, but I have copies of everything. If she threatens me, I'm filing harassment charges and a restraining order." Rachel's voice steadied with determination. "I've been afraid of her for 3 years. I'm done being afraid." She left for the meeting. I forwarded the folder contents to Marcus Webb, the Arizona Department of Real Estate, and the Attorney General's office. Then I strapped Tyler into his car seat and drove to the HOA meeting. The community center meeting room was packed. Word had spread about the viral video. Neighbors filled every chair and lined the walls. I recognized faces from the videos: Mrs. Patterson, the Hendersons, Mark Chen. Families who'd been silently suffering under the board president's tyranny. They were done being silent. Diane sat at the board table looking increasingly uncomfortable as more people arrived. The other board members, Linda Vance and Steve Morrison, kept glancing nervously at the crowd. Rachel sat at the far end of the table, hands folded, expression calm. At 7 p.m., Diane called the meeting to order. "This is an emergency session to address a safety concern regarding—" "Point of order," Rachel interrupted. "Before we proceed, I need to make a statement to the community." Diane's jaw tightened. "We have an agenda." "I'm the treasurer. I have financial information the community needs to hear. You can table the agenda, or I can call the Arizona Department of Real Estate investigator who's sitting in the back row to come forward and explain why he's here." I turned. A man in a suit stood in the back corner, holding a briefcase and a badge. Every eye in the room swiveled to him. Diane's face went pale. "Rachel, what did you do?" "I did what I should have done 3 years ago. I told the truth." Rachel stood and addressed the crowd. "I'm Rachel Torres, HOA treasurer for the past 5 years. During my tenure, I've witnessed and participated in financial fraud, illegal fine collection, and systematic abuse of authority. Tonight, I'm resigning from the board and cooperating with state investigators to expose corruption that has cost this community over $47,000 in illegal fines." The room erupted. Diane shot to her feet. "You're making false accusations. I'll sue you for defamation." "With what money?" Rachel's voice cut through the chaos. "Your personal accounts are about to be frozen pending embezzlement charges. The Attorney General has evidence of your self-dealing scheme. The Department of Justice is investigating disability discrimination. And there are 3 videos of you assaulting a disabled child that have been viewed over 2 million times." The woman from the corner lot stood frozen, finally understanding that her empire was collapsing in real time. "This meeting is over," Diane said, grabbing her bag. "No, it's not." The DRE investigator stepped forward, showing his badge. "I'm Special Agent Michael Torres with the Arizona Department of Real Estate. Ms. Kowalski, you're required to surrender all HOA records, financial accounts, and property in your possession immediately. This HOA is now under state investigation." Diane's hands shook. She looked around the room desperately, searching for support. She found none, only angry faces, betrayed neighbors, people she'd fined and threatened and controlled for 6 years. "I want my son's xylophone back," I said into the silence. "Tonight." The self-appointed enforcer looked at me with pure hatred. "It's evidence." "Of what? A legal activity? A disabled child's medical therapy? Return it now or add theft charges to the embezzlement and assault charges you're already facing." Agent Torres nodded. "Ms. Kowalski, return the child's property immediately." For a long moment, I thought she'd refuse. Then she walked to her bag, pulled out Tyler's rainbow xylophone, and dropped it on the table. The sound of plastic hitting wood echoed through the silent room. I picked it up carefully. Jennifer's fingerprints were still visible on the keys. Tyler's name was still written on the bottom in his mother's handwriting. I held it against my chest and looked at the tyrant who'd stolen it. "You're done," I said, quietly. Diane Kowalski left the meeting room without another word. She'd never hold power in Pinewood Meadows again. If you've ever watched someone's abuse of power finally catch up to them, hit subscribe now, because watching this HOA president face criminal charges is even more satisfying than you think. Thursday morning, Marcus Webb filed our civil lawsuit in Maricopa County Superior Court. By noon, a process server had delivered the summons to Diane Kowalski's home. By 2 p.m., She'd hired Kenneth Briggs, an attorney known for defending HOA boards in disputes. Expensive, aggressive, and according to Webb, not as good as he thinks he is. Briggs specializes in intimidation, Webb explained over the phone. He'll file motions to dismiss, try to drag this out, exhaust your resources. But he's never dealt with a case where his client is on video assaulting a child. And he's definitely never dealt with state and federal agencies investigating simultaneously. How long until trial? 8 to 12 months normally, but we can push for expedited hearing on the disability discrimination claims. Federal ADA cases get priority. Webb paused. Nathan, I need you to prepare for something. This is going to get ugly. Diane will try to discredit you, claim you're an unfit parent, suggest Tyler's autism makes him aggressive. She'll do anything to justify her assault. Let her try. I have 3 videos, medical documentation, and expert testimony. Good, because Briggs is already filing a counterclaim. Says you've been harassing his client, that Tyler's noise constitutes nuisance, that you're trying to extort money through false accusations. I felt cold anger settle into my bones. She assaulted my son and she's claiming I'm extorting her? Classic defense strategy, muddy the waters, create false equivalence, make the victim look like the aggressor. Webb's voice hardened. Which is exactly why we're not settling. We're taking this to trial and we're destroying her credibility completely. Friday, the Arizona Attorney General's office sent a formal notice. Diane Kowalski was under investigation for embezzlement, fraud, and abuse of public trust. Her personal bank accounts were frozen pending audit. The HOA's accounts were placed in receivership under state supervision. Rachel called that afternoon. Agent Torres interviewed me for 4 hours yesterday. Wanted details on every financial transaction, every forged document, every time Diane told me to falsify records. He's building a criminal case. How much trouble are you in? My attorney negotiated immunity in exchange for full cooperation. I'm testifying against her. I have to surrender my teaching certificate temporarily while the ethics board reviews my conduct. But I keep my job. Her voice wavered. It's humiliating, but necessary. You're doing the right thing. I hope Tyler knows that. I hope he understands that adults failed him. But some of us are trying to make it right. I looked at Tyler sitting on the floor with his xylophone. He'd been holding it since Tuesday night but hadn't played it, just held it, rocked with it, slept with it beside him. He will, I said, eventually. The Department of Justice response came Monday. Tyler's case met criteria for ADA investigation. A federal compliance officer would be assigned. The HOA had 30 days to submit all documents related to their noise policies and how they'd handled Tyler's accommodation request, which they couldn't do because there was no accommodation request process. Because the noise policy was illegal, because they'd never considered federal disability law when implementing their rules. The compliance officer, David Chen, called me Wednesday. Mr. Cross, I've reviewed your complaint and supporting documentation. This is one of the clearest ADA violations I've seen in residential settings. Your son's outdoor therapy was reasonable accommodation, below legal noise thresholds, time-limited and medically necessary. The HOA's refusal to accommodate was discriminatory. Their enforcement through physical assault compounds the violation. What happens now? DOJ files a formal complaint against the HOA. We can seek injunctive relief, mandate policy changes, require disability training for the board, and impose civil penalties. In cases involving assault on disabled minors, penalties can be substantial. How substantial? $50,000 to $75,000, plus attorney fees. plus compensatory damages to you. Chen's voice was professionally neutral, but I heard satisfaction underneath. The message needs to be clear. You cannot assault disabled children for engaging in protected therapeutic activities. By the end of February, the siege was complete. Criminal investigation. Maricopa County DA preparing assault and theft charges. Civil lawsuit. Filed, discovery phase beginning. State investigation, Arizona DRE audit ongoing, embezzlement charges pending. Federal investigation, DOJ ADA complaint filed. Penalties recommended, HOA status. Board dissolved, receivership established, new elections required, and the media wouldn't let it go. Channel 12 did a follow-up story. Autistic boy's xylophone returned after viral video. Local newspapers picked it up. National disability rights organizations cited Tyler's case in advocacy campaigns. Diane Kowalski became the face of HOA overreach and disability discrimination. Her attorney filed motion after motion, trying to suppress the videos, dismiss the charges, claim qualified immunity. Every motion was denied. Because you can't claim immunity for assaulting a child, no matter what title you hold. Tyler started therapy 3 times a week with Dr. Chen. She used play therapy, art therapy, gentle trauma processing, slowly, carefully, helping him rebuild his sense of safety. He still didn't speak, but he started playing the xylophone again. Just a few notes at first. Not the full song, but it was progress. One afternoon in March, I found him in the front yard. The first time he'd gone outside voluntarily since the assault. He was sitting on the grass with his xylophone, playing those familiar notes, the song his mother had taught him. I sat beside him. "That sounds beautiful, buddy." Tyler looked at me, his eyes filled with tears, and he whispered, so quiet I almost didn't hear it. "I miss Mommy." 3 words, the first words in 6 weeks. I pulled him into my arms and held him while we both cried. "Me too," I whispered. "Me too." April brought depositions. Diane's attorney, Kenneth Briggs, approached mine like ammunition stockpiling for war. He deposed me first, 4 hours of hostile questions trying to establish that Tyler was disruptive, that I was negligent, that the neighborhood had legitimate concerns. "Mr. Cross, isn't it true your son has violent outbursts?" "No, Tyler has autism. He has sensory sensitivities and requires routine. He's never been violent. But he has meltdowns, correct? Where he screams and throws things? Meltdowns are neurological responses to sensory overload. They're not violent episodes, and they happen inside our home, not in public areas." I kept my voice level, despite wanting to leap across the table. Unless someone physically assaults him, then yes, he has meltdowns. Briggs tried a different angle. "You work from home, correct?" "Yes." "So you're present when your son is outside?" "Not always immediately visible, but yes, I'm home." "Then where were you when Ms. Kowalski allegedly—" "There's no allegedly. 3 cameras captured her dragging my son across the lawn. I was in my home office on a conference call. I came out the moment I heard Tyler screaming." "So you admit you weren't supervising him?" Marcus Webb interrupted. "Tyler is 8 years old, playing in his own front yard during daylight hours in a residential neighborhood. He doesn't require direct supervision for that activity." "Are you suggesting parents must physically watch their children every second?" Briggs ignored him. "Mr. Cross, has Child Protective Services investigated your parenting?" "Yes, because Dr. Kim reported Diane Kowalski's assault as required by mandatory reporting laws. CPS investigated her, not me. The case was closed with no findings against me and a referral for criminal charges against Ms. Kowalski." The deposition continued in that vein. Briggs trying to make me look negligent. Me calmly presenting facts. Webb objecting to improper questions. Finally, Mr. Cross, what exactly do you want from my client? I want her to face consequences for assaulting my disabled son. I want my son to receive compensation for the trauma she caused. I want the HOA's illegal rules eliminated so no other family goes through this. And I want Diane Kowalski permanently barred from any position of authority over other people's lives. That sounds like vengeance, not justice. Vengeance would be what I wanted to do when I saw that video. Justice is what I'm pursuing through legal channels. Diane's deposition was 2 days later. Webb eviscerated her. Ms. Kowalski, walk me through your decision-making process when you grabbed Tyler Cross. I was enforcing the noise ordinance. The child was creating a disturbance. The child was playing a xylophone that measured at 52 decibels. Normal conversation is 60 decibels. Was his play actually disturbing you? It was annoying, repetitive. Annoying. So you grabbed an 8-year-old child and dragged him across his own lawn because you found his play annoying. I was confiscating noise-making equipment that violated community standards. You're not law enforcement. You have no authority to confiscate anyone's property. Webb slid documents across the table. These are Arizona statutes regarding HOA authority. Can you show me where HOA board members are granted power to seize private property? Diane's attorney objected. She didn't answer. Let me ask a different question. Did you know Tyler has autism? I knew he had some kind of condition. Autism spectrum disorder. Did you know his outdoor play was prescribed therapy? Parents claim all kinds of things are therapy. Did you know? Webb's voice sharpened. I'd heard rumors. You'd heard rumors. Did you ask for medical documentation before restricting his activity? I'm not required to. Yes, you are. Under the Americans. With Disabilities Act, HOAs must consider reasonable accommodation requests. Did Tyler's father request accommodation? He mentioned his son's needs, but did you deny that request? There was no formal request, because your HOA has no accommodation request process, correct? You've never implemented ADA compliance procedures despite being legally required to do so. Diane's face flushed red. We're a volunteer board. We can't be expected to know every law. You're a former paralegal who lost her license for falsifying documents. You claimed expertise in legal matters when you became board president. Did that expertise somehow not extend to federal disability law? Briggs objected. Webb withdrew the question. Let's talk about the noise ordinance. You implemented a rule restricting residential noise to 50 decibels, correct? To maintain quality of life? Arizona state law sets residential noise limits at 65 decibels. Your rule is more restrictive than state law. Did you get membership approval for this rule? The board has authority. Arizona Revised Statutes, Section 33, 1808, requires HOA rules to comply with state law. Your rule doesn't. It's void. Every fine you've collected under it was illegal. Webb pulled out financial records. Over 6 years, you collected $47,000 in noise violation fines. You personally received $7,100 through a fabricated enforcement coordinator position. That's embezzlement, Ms. Kowalski. I was compensated for my time. Your time enforcing illegal rules, collecting fraudulent fines, and ultimately assaulting a disabled child when his father challenged your authority. The deposition deteriorated from there. Diane getting defensive, contradicting herself, admitting to actions that undercut her legal position. By the end, Even Briggs looked resigned. May brought the Arizona Department of Real Estate hearing. Not a trial, but an administrative proceeding to determine whether the HOA had violated state law and what penalties were appropriate. The hearing room was formal but not intimidating. An administrative law judge, Maria Santos, presiding. Representatives from DRE. The HOA's receiver, Rachel Torres as cooperating witness, and Diane Kowalski, looking smaller every time I saw her. Agent Michael Torres presented findings. HOA noise ordinance violated ARS, Corf 33, 1808, 87 illegal fines issued totaling $47,000, embezzlement of $7,100 through fraudulent enforcement fees. No proper board votes on major decisions, financial records falsified with treasurer's coerced participation, pattern of targeting families with children for excessive enforcement. This HOA operated as a personal fiefdom for Ms. Kowalski, Torres concluded. She created rules without authority, collected money illegally, enriched herself through fraud, and ultimately assaulted a resident's child when challenged. The violations are systematic and severe. Judge Santos reviewed the evidence for 3 hours, then delivered her ruling. The Pinewood Meadows HOA violated Arizona law through implementation and enforcement of rules exceeding statutory authority. All fines collected under the illegal noise ordinance must be refunded with 6% interest. Ms. Kowalski is personally liable for embezzled funds and is permanently banned from serving on any HOA board in Arizona. The HOA must implement mandatory ADA compliance training and establish proper accommodation request procedures. Civil penalties, $45,000 payable to the state. This board is dissolved. New elections will be supervised by DRE to ensure proper governance. Diane sat frozen as her world ended. $45,000 in state penalties, $7,000 in restitution for embezzlement, $47,000 in fine refunds, plus legal fees, plus the pending federal penalties, plus my lawsuit. She'd lose everything. And Tyler still wasn't fully speaking. Justice was coming, but healing would take longer. The criminal trial was scheduled for July. Simple assault on a minor and theft, misdemeanor charges that carried maximum penalties of 6 months jail time and $2,500 fine per count. The Maricopa County prosecutor, Lisa Hammond, wasn't satisfied with that. Given the victim's age, disability, and the defendant's abuse of authority, we're pushing for maximum sentencing, plus restitution, she told me in a pre-trial meeting. We want Diane Kowalski to serve actual jail time, not just probation. Will that happen? With the video evidence? Strong possibility. Juries don't like seeing adults hurt children. Add in the disability discrimination aspect, and her embezzlement conviction. Yes, she'll likely do time. The embezzlement conviction had come through in June. Diane had pled guilty to felony fraud and theft rather than face trial. Sentenced to 2 years in prison, suspended pending successful completion of 5 years probation. Restitution of $54 to $100 to the HOA and affected homeowners. But if she was convicted of assaulting Tyler, that probation would be revoked. She'd serve the full 2 years, plus any additional sentence from the assault conviction. Tyler was improving, speaking more, still hesitant, still quiet, but words came more frequently. He'd started playing with other children again, started going outside without fear. Dr. Chen said he was resilient, that children can heal if given safety and support. But he still had nightmares about Diane, still flinched when he heard loud voices, still avoided the front yard where the assault happened. Some trauma leaves permanent marks, Dr. Chen told me. Tyler will carry this experience with him. The goal isn't to erase it, it's to integrate it into his story in a way that doesn't define him. July 15th. The trial began. I sat in the courtroom gallery while Prosecutor Hammond methodically built her case. The 3 videos played on screens for the jury. Tyler's screams echoed through the IJU room. Several jurors visibly recoiled when Diane dragged him across the lawn. Dr. Kim testified about Tyler's injuries and the selective mutism that followed. Dr. Martinez explained autism spectrum disorder and why sensory play therapy is medically necessary. Dr. Chen described the trauma and ongoing psychological harm. Tyler lost his voice for 6 weeks, Dr. Chen told the jury. He lost his sense of safety. He lost trust in adults and faith that rules would protect him. Ms. Kowalski didn't just hurt him physically. She destroyed his ability to feel secure in his own home. The defense tried to argue accident, misunderstanding, good intentions. Tried to suggest Tyler had been aggressive first, that Diane was protecting herself. Then Hammond played the unedited footage, full audio, Tyler playing peacefully, Diane approaching already angry, no provocation, no threat. Just a child with a xylophone and a woman who decided he didn't have the right to play it. The jury deliberated for 90 minutes. Guilty on both counts. Sentencing was scheduled for August. Kenneth Briggs filed motion after motion for leniency. Character witnesses testified that Diane was a dedicated volunteer, a loving aunt, a responsible board member who'd made mistakes under stress. Hammond countered with testimony from families Diane had harassed over 6 years, parents who'd paid illegal fines, children who'd been targeted for being too loud while playing, a community terrorized by one woman's need for control. Diane Kowalski didn't make mistakes, Hammond told the judge. She systematically abused her authority, violated state and federal law, stole from her community, and assaulted a disabled child when his father dared to challenge her. She's shown no remorse, no acknowledgement of wrongdoing, no empathy for the child she traumatized. The judge, Michael Warren, 20 years on the bench, reviewed everything, then looked directly at Diane. Ms. Kowalski, you were given a position of trust. You were supposed to serve your community. Instead, you exploited that position for personal gain and ego gratification. You created illegal rules, collected fraudulent fines, enriched yourself through embezzlement, and when confronted with your abuse of power, you physically assaulted an 8-year-old autistic child engaged in medical therapy. He paused. Your actions were not mistakes. They were choices, deliberate, repeated choices to harm others for your benefit. On the assault charge, 6 months in county jail. On the theft charge, 6 months in county jail to run consecutively. Total sentence, 1 year. Additionally, your suspended prison sentence for embezzlement is hereby revoked. You will serve the full 2 years. Total incarceration, 3 years. Diane's face crumpled. Her attorney moved for bail pending appeal. Denied. She was led out of the courtroom in handcuffs. The civil trial was scheduled for October, but Briggs approached Webb with a settlement offer in September. My client wants to resolve this, Briggs said, in mediation. She'll pay $100,000, return all HOA property, agree to permanent injunction against contact with your clients, and issue a public apology. Webb looked at me. I thought about Tyler, about 3 years of prison Diane would serve, about the $100,000 that could pay for years of therapy and create a trust fund for Tyler's future needs, about the public apology that would acknowledge what she'd done. I want the apology in writing, I said. Specific. Acknowledging the assault, the disability discrimination, the theft of my son's property, and the harm caused. I want it published in the neighborhood newsletter, posted on the HOA website, and sent to every homeowner in Pinewood Meadows. Briggs looked pained, but nodded. Agreed. And I want one more thing. I held Webb's eye. $25,000 of that settlement goes to establish a disability accommodation fund. Any family in Pinewood Meadows with a disabled child can apply for financial assistance with adaptive equipment, therapy costs, or legal fees if they face discrimination. The fund will be named after Tyler's mother, the Jennifer Cross Memorial Disability Support Fund. Webb smiled. That's inspired. Diane's written apology arrived 2 weeks later. 3 pages of acknowledgement, remorse, and acceptance of responsibility. I, Diane Kowalski, acknowledge that on April 3, 2024, I physically assaulted Tyler Cross, an 8-year-old child with autism spectrum disorder, while he was engaged in prescribed medical therapy in his own front yard. I grabbed his arm, dragged him across the lawn, confiscated his therapeutic equipment, and caused him physical and psychological harm, including trauma-induced selective mutism. My actions were wrong, illegal, and inexcusable. I violated Tyler's rights under the Americans with Disabilities Act, violated Arizona HOA law, and betrayed the trust of my community. I caused immeasurable harm to a vulnerable child and his father, who was honoring his late wife's wish to protect their son's therapeutic needs. I am deeply sorry for my actions and accept full responsibility for the consequences. I hope Tyler and his father can eventually find peace. Though I understand I have no right to ask for forgiveness. It was published everywhere. The HOA newsletter, the community website, sent to all 180 homes. The tyrant who'd ruled through fear had been forced to publicly confess her sins. The new HOA board was elected in November, a slate of parents who'd lived under Diane's tyranny and were determined to build something better. Miguel Santos, father of 3, was elected president. His first act was inviting me to the inaugural board meeting. "Nathan, we want to do this right," he said. "We're rewriting the CC&Rs from scratch, implementing proper ADA compliance, creating transparency, and we want your input." The meeting was nothing like the old board's sessions. No aggressive enforcement, no targeting families, no invented rules, just neighbors trying to maintain a community. "First order of business," Miguel announced. "I motion to formally apologize to Nathan and Tyler Cross on behalf of Pinewood Meadows for the harm caused by the previous board's illegal actions. Second, I motion to name the community trail system Tyler's Trail, in recognition of his courage and his family's fight for disability rights." The vote was unanimous. Tyler's Trail was dedicated in December, a small ceremony with neighbors, the new board, and a bronze plaque that read, "Tyler's Trail, dedicated to all children who deserve safe spaces to play, heal, and grow. May we always remember that community strength comes from protecting our most vulnerable members, not silencing them." Tyler stood beside me at the ceremony, holding his xylophone. He'd started playing it outside again, carefully at first, then more confidently as weeks passed and nothing bad happened. "Do you want to play Mom's song?" I asked quietly. He looked at the crowd, at the neighbors who'd supported us, at the new board that had apologized and named a trail after him, and he nodded. Tyler sat on the grass and played the simple melody Jennifer had taught him, the same notes he'd been playing when Diane had assaulted him, the same song that had connected him to his mother through grief and trauma. But this time, nobody stopped him. Nobody grabbed him. Nobody told him he was too loud or wrong or unwelcome. The crowd listened in respectful silence. Some people cried. When Tyler finished, they applauded. My son smiled, the first real, genuine smile I'd seen since before the assault. Christmas brought news from the federal level. The Department of Justice had completed their ADA investigation and issued findings. Pinewood Meadows HOA violated the Americans with Disabilities Act through failure to provide reasonable accommodation, discriminatory enforcement of rules against a disabled minor, and physical assault during therapeutic activity. Civil penalties: $75,000 payable to the federal government. Compensatory damages to Tyler Cross, $50,000. The HOA must implement comprehensive ADA training, establish clear accommodation request procedures, and submit to federal monitoring for 3 years. Combined with the state penalties, the restitution, the settlement, and legal fees, Diane Kowalski's reign of terror had cost the HOA over $300,000, but it had also freed 180 families from fear. January marked 1 year since the assault. Tyler's therapist said he'd made remarkable progress, speaking fluently, engaging socially, managing his autism with healthy coping strategies. "He'll always carry the trauma," Dr. Chen told me, "but he's integrated it into his story. He knows what happened, he knows it was wrong, and he knows that adults fought for him and won. That gives him a foundation of trust that many trauma survivors never get." Tyler started speaking at school about his experience. Not dwelling on the assault, but talking about autism, about sensory needs, about how communities should accommodate differences. His second-grade teacher called me in tears. "Nathan, Tyler gave a presentation about autism awareness today. He explained his sensory toys and why he needs them. Then he played his xylophone and told the class it was from his mom who died. Every kid in that room understood. They asked questions. They were respectful. Tyler taught them empathy. My son, who'd lost his voice for 6 weeks, who'd been traumatized by an adult's cruelty, had found the courage to educate others about difference and acceptance. Jennifer would have been so proud. February brought final closure. The Arizona Court of Appeals rejected Diane's appeal of her criminal conviction. The sentence stood: 3 years in prison, no early release. The civil settlement was finalized. $100,000 paid. The Jennifer Cross Memorial Disability Support Fund established with $25,000 initial funding. Permanent injunction prohibiting Diane from any contact with Tyler or me. And the new HOA thrived. Transparent finances, reasonable rules, active disability accommodation, no more tyranny. Pinewood Meadows became what it was always supposed to be, a community that supported families instead of controlling them. March 15th, Tyler's 9th birthday. We celebrated in our front yard with his classmates, his therapy team, and neighbors who'd become friends. Tyler played his xylophone for everyone. Not just the song his mother taught him, but new songs he'd learned. Complex melodies that showed how much he'd progressed. After cake, Rachel Torres pulled me aside. She'd been convicted of falsifying financial records, but received probation and community service due to her cooperation. She'd lost her board position, but kept her teaching job. "Nathan, I want to apologize again. I should have stopped Diane years ago. I should have protected Tyler and every other family she targeted." "You did eventually. That matters." "I don't know if it's enough." "It's enough for Tyler. He knows you helped us, that you gave us the evidence that took her down." I looked at my son laughing with friends. "You were scared. I understand that. But when it counted most, you chose to be brave. That's what Tyler will remember." Rachel's eyes filled with tears. "Thank you for that, Grace. I don't deserve it." "Maybe not, but you're working to earn it. That's what redemption looks like." That evening, after guests had left and Tyler was asleep, I sat in our front yard with Jennifer's photo. "We did it," I whispered to her image. We kept our promise. Tyler's happy. He's healing. He's safe. I played the video she'd recorded, the one where she played the xylophone and told Tyler she'd always make music with him. Even after death, even through trauma, even across the darkest moments, she'd been right. The music continued. Tyler's voice continued. Our family's story continued. And Diane Kowalski's attempt to silence us had failed completely. Justice doesn't always come easy. But it comes. And sometimes that's enough. 2 years after the assault, Tyler and I returned to the memorial bench where we'd scattered Jennifer's ashes. The same bench that sat beside Tyler's trail, the path he'd fought so hard to use. Tyler was 10 now, taller, more confident, still autistic, still needing his routines and sensory tools, but thriving in ways I'd feared might never be possible after Diane's assault. He carried his xylophone, the same rainbow-colored one his mother had bought him, worn now from years of use and love, but still functional, still producing the same notes Jennifer had taught him. "Dad?" Tyler looked at the plaque. "Do you think Mom knows we won? I think she's proud of you for being so brave, for healing, for teaching other kids about autism. I wasn't brave. I just played my xylophone. That's exactly what made you brave. You kept being yourself even when someone tried to stop you. You didn't let fear silence you forever." I put my arm around him. "That's the bravest thing anyone can do." Tyler played the melody his mother had taught him. The notes drifted across the quiet afternoon, mixing with birdsong and distant children's laughter from the playground. No one stopped him. No one complained. No one measured decibels or issued violations. Because Tyler had every right to be there, every right to play, every right to exist as himself without fear. We'd proven that in criminal court, civil court, state administrative hearings, and federal investigations. We'd proven it with audio engineering data, medical testimony, legal precedent, and 3 videos that showed exactly what tyranny looks like when given power over vulnerable people. Diane Kowalski served her full 3-year sentence. Released in early 2027, she moved to another state where her conviction record and permanent HOA ban meant she'd never hold authority over anyone again. The Pinewood Meadows HOA flourished under new leadership, transparent, accountable, actually family-friendly instead of just marketing themselves that way. The Jennifer Cross Memorial Disability Support Fund grew to $75,000 through donations from families across Arizona who'd heard our story. It had helped 23 families with disabled children access therapy, equipment, and legal support when they faced discrimination. Tyler's trail became a symbol. Other neighborhoods in Arizona contacted us asking how to implement similar protections. The state legislature passed new laws requiring HOA boards to receive mandatory ADA training. Several bills were introduced to strengthen oversight of HOA financial practices. Our case had ripple effects far beyond one assault, one family, one neighborhood. Tyler started middle school in August 2026. He joined the music program, playing percussion instruments that expanded far beyond his childhood xylophone. His teachers said he had natural rhythm and emotional expressiveness that made his playing distinctive. He made friends, real friends who accepted his autism, understood his needs, and valued him for exactly who he was. And he spoke publicly about his experience, not as a victim, but as someone who'd survived, fought, and won. At a disability rights conference in Phoenix, Tyler told his story to a room of advocates, attorneys, and families dealing with discrimination. "When I was 8 An HOA president dragged me across my lawn and took my mom's xylophone because she said I was too loud, he began, his voice steady despite the crowd. She was wrong. I wasn't too loud. I was just existing as an autistic kid who needed sensory play to deal with losing my mom. And that woman decided I didn't have the right to do that in my own yard. The room was silent, attentive. My dad fought for me using science and law and courage. He proved that what she did was wrong in every way, legally, morally, humanly, and she went to prison for it. Tyler paused. But here's what I want other disabled kids to know. You have rights. You don't have to be quiet or invisible or ashamed. You can exist loudly, weirdly, differently. And if someone tries to stop you, there are people who will fight for you. He received a standing ovation. I stood in the back of the room, crying proud tears, watching my son inspire hundreds of people with his story of survival and advocacy. Jennifer would have been so incredibly proud. That evening back home, Tyler and I sat in our front yard, the same yard where the assault had happened. The place I'd feared he might never feel safe again, but we'd reclaimed it, transformed it from a site of trauma into a space of healing and defiance. Tyler played his xylophone while fireflies emerged in the twilight. Neighbors walking past waved and smiled. Children rode bikes down Tyler's trail. The community existed as it should, peacefully, inclusively, without fear. "Dad," Tyler stopped playing, "I'm glad you didn't give up. I could never give up on you, buddy. But it would have been easier to just move away, to let her win." Easier, yes, but wrong. I looked at him seriously. "Your mom made me promise to protect you and keep you happy. Fighting Diane was the only way to do both. You couldn't be happy while being targeted, and I couldn't protect you without standing up to her. I'm happy now. I know, me too." Tyler smiled. "I think I want to be a lawyer when I grow up, like Mr. Webb, so I can fight for kids like me." My heart swelled with pride. "You'd be an excellent lawyer, or maybe an audio engineer like you, measuring sound and proving when people are wrong about noise." He considered. "Or a therapist like Dr. Chen, helping kids who've been hurt." "You've got time to decide. But whatever you choose, you'll be amazing." Tyler went back to playing his xylophone. The melody drifted through the evening air, a testament to resilience, justice, and the unbreakable bond between a father and son who'd fought tyranny together and won. I pulled out my phone and recorded Tyler playing, just like Jennifer had done years ago, capturing this moment of peace and progress, documenting how far we'd come. And I thought about the journey from assault to advocacy, from trauma to triumph, from a child who'd lost his voice to a young man who used it to inspire others. The fight had been exhausting, expensive, emotionally devastating at times, but absolutely worth it, because Tyler was safe, happy, thriving, because Diane Kowalski's abuse of power had been exposed and punished, because 180 families were free from her tyranny, because other disabled children would be protected by the legal precedents we'd established, because justice, though delayed and hard-won, had prevailed. The legacy. Tyler Cross's case became Arizona precedent for HOA ADA compliance. Every HOA board in the state received notice that disability accommodation is not optional, it's federal law. The Jennifer Cross Memorial Disability Support Fund continues growing and helping families. Tyler's trail stands as a reminder that communities exist to support families, not control them. And somewhere in a federal database, Diane Kowalski's convictions serve as warning to every HOA board member who thinks authority means power without accountability. It doesn't. Authority without accountability is tyranny, and tyranny eventually falls. Thank you for following Tyler's story. If this fight for disability rights and family protection resonated with you, hit subscribe. Share it with someone who needs to hear that bullies can be beaten, that justice exists, and that protecting our children is always worth the fight. Where are you watching from? Drop a comment below, and remember, you are not powerless, even against HOAs, even against authority figures, even when the odds seem impossible. Document everything, know your rights, fight for what matters, and never, ever let anyone silence your child.